Welcome to the session called Love Thy Neighbor and Your HOA, Reducing Conflict in Community Associations. My name is not Julie Howard, as the script says. My name is Amy Tinetti. Hope you're enjoying this year's law seminar. Presenting today are Edward Hoffman, Esquire, CCAL, Hoffman Law, LLC in Allentown, Pennsylvania. Emmy Kinnard, Oratel, I don't know how to pronounce that. I did not have time to rehearse, I apologize. Kelly, Herbert, and Crawford, Nashville, Tennessee. And Jennifer Wojciechowski. When I walked in, I'm like, oh man, I have to introduce Jennifer? I need a refresher. So she was very nice and spelled it out for me phonetically. CERMS and CCAL, impressive. Community Association Underwriters of America, Newtown, Pennsylvania. You can view and download session handouts and resources from the Law Seminar app. If you have any difficulty locating today's materials, please feel free to stop by the event registration desk for assistance. In addition to accessing the handouts, you can review the backgrounds of our presenters and other materials to enhance your event experience. Please be sure to evaluate the program using the survey at the end of the session. This session is being recorded. I now turn your attention to our panelists. Please enjoy the session.
Thank you, Amy. That's not our PowerPoint, by the way. It'd be helpful if we actually had a PowerPoint. I would think this was somebody else's job to do this. Right from the beginning. All right, there you go.
All right. Let me make sure this works. All right, can you all hear me? Is this microphone working? Or?
I would have thought that would have been somebody else's job.
Got nothing? Oh?
Oh.
No?
We don't need it.
No, I need it for the recording.
You can just sing.
It would not be a good situation. Now I hear it. Now I hear it.
Oh, that's even worse.
All right, how's that? Is that better?
Yes.
All right, thank you. Well, thanks for joining us today for our presentation. We're going to try and talk about love. And by the way, this came to me as I was sitting there when the topic was introduced, Love Thy Neighbor. It's not Love with Thy Neighbor, so I don't know what seminar you're here for, but
Love knowing your neighbor.
yeah, in case it's that one, it's not the one we're going to talk about. But we're going to try and talk about some conflict resolution issues that pop up and things you can do to reduce conflict in HOAs and take it back to your clients, which is why we're all here. So and my presentation is going to be from the perspective of general counsel with perhaps some insurance defense stuff mixed in. Emmy's here more on the ADR and the defense side, and Jen's here to provide some input with respect to insurance issues, coverage issues that become present with conflict and dispute in community associations. So the best way to reduce conflict, in my opinion, one of the best ways, consistency and uniformity in enforcement. I'm going to probably go over here. So what does that mean? It basically means you have to make decisions the same way, right? Boards have to do their elected job. Board has a fiduciary duty, and you all know this, with enforcing community's covenants, restrictions, rules, and regulations for the benefit of every homeowner, okay? So it must be followed by every member and owner. What I mean by that is the rules are there, the covenants are there, and the people have to follow them. It's the board's job to make sure they do, and it's the board's job to not pick and choose what it wants to enforce and what it doesn't want to enforce. Must enforce compliance and against every owner. Critical, right? Can't pick and choose which owners. And no playing favorites. What are examples we see all the time as association attorneys and people in the industry? Frequently encountered enforcement issues: pools, trash, outdoor, parking, pets, animals, curtains, outdoor storage issues, maintenance, playgrounds. And some of them bring about their own issues, like playgrounds might have familial status discrimination, allegations attached to them. Maintenance issues might have other conflict-related issues attached to them, et cetera. That sign actually is pretty funny. I saw that. That's a boilerplate sign, but I actually saw a sign like that in one of my clients' communities. I said, why would you even need to put this sign up? And they said, people claim they don't remember. They don't remember they have to pick up dog poop. So yeah, that's where we are in today's world. And I can tell you a cat poop story one day too, but not today. So I'm going to go over 9 ways to reduce conflict in associations. One is something we already touched on. So enforce the covenants, restrictions, rules, and regulations. That is almost so self-explanatory that it begs the question, why did I even put it on there? Because boards a lot of times don't want to do that. They want to pick and choose the easy stuff, and they don't want to enforce the tough stuff, right? Sometimes when it's pets or dogs, boards like dogs, they're emotionally attached, and they're like, well, we're gonna let that go. But when it's something else, like a garden gnome, because I think universally most people, does anyone here like garden gnomes? Okay, I got one, always one. Actually, I had a few people here. Garden gnomes, universal. If you're not allowed to have things in your mulch, you're not allowed to have things in your mulch. So tell people they got to get rid of it. But don't pick and choose the fun stuff or the good stuff and keep that and then go against everything else. And it's the same with respect to number 2, favorites between the pariah in the community and the nicest grandma, grandpa, nicest person ever. Because they could be doing the same thing, but because the nice person baked cookies, which by the way, that's cool, but baked cookies and brought them to the clubhouse for the meeting, but is still violating everything, it means you still have to enforce against them. The pariah, on the other hand, is the one that the lawyers will get the emails directly from, sometimes 5 a day, and they say what you expect them to say. The association is violating this. The association is violating that. I'm reporting you to the Attorney General's office. I'm reporting you to the Bureau of Consumer Protection. I'm reporting, whatever it is, it's that person. Oh, and by the way, that person also has garden gnomes. So you can't pick and choose, and I tell my clients that. Everyone, everything, right?
I did warn Ed that I was going to interrupt because I can't just sit here since I'm third. And it's just not, I have that, don't have that ability. So Ed, I was thinking with regards to 1 and 2, wouldn't, I know firms in the community association space do the board training, and after an election, for consistency from
Right.
election when new members come on the board, wouldn't board training be a great idea and a great opportunity to get in front of them and remind them, how you were operating, the way you were enforcing, we need to maintain that consistency even though there's been a change in some of the board member composition.
No, that's a great point. Frankly, I've done that numerous times myself. With the law firm, I've done that, just meeting with clients via Zoom during COVID when new boards come in, and in person pre and post. But CAI also has a great board member training. It's an all day. It's usually a Saturday. It used to be in person. Now it's virtual, I believe, but it's an all-day board leadership training seminar, and I've taught that like 10 times. It's a great kind of soup to nuts welcome to the board, and you're correct, because sometimes the board members are the smartest people in the world. They were CEOs, they own businesses, professors. I won't say lawyers. It's a joke, smartest people in the world. But they had lives separate and distinct from serving on the board, and then they come on the board and they either don't know anything about being on a board or they think they know everything about being on a board, right? And frankly, everyone can use some training sometimes for something. tell me what I'm doing wrong. Tell me right now, by the way. I'm kidding. So Jen will do that. That's her job. So at number 3, we'll go avoiding stupid decisions. And what do I mean by that? And why would that lead to conflict? Well, it will lead to conflict because if a board makes a decision and it's just patently dumb, I mean, owners are going, it's usually financially related thing they do, like spend money, don't vet the contractor, reverse course on something they shouldn't have reversed course on. People are astute to that. So if it's open meetings, I know in California, I think you have open meetings. Pennsylvania, we don't. But people are astute. And even if they don't go to the meetings, they will review the minutes, they'll look, and then they'll wonder why you're doing it. So if you make stupid decisions, by the way, everyone does sometimes. But how do you avoid them? So adopt and implement an enforcement policy which will be applied uniformly and equally to all owners, okay? So if you're going to do something that affects the membership, have a policy, follow the policy. Don't deviate from the policy. Again, reasonableness and act the same. And recognize and reverse course if necessary in order to avoid conflict. If you know you made a stupid decision and you can reverse it and the impact will be minimal, hopefully minimal, reverse it. Sometimes you just swallow your pride and you reverse it and you say, here's what we did, we're going to move on. Number 4, due process. That's a critical cog in trying to reduce conflict. And actually, I think the due process opportunity, and by the way, the statutes in Pennsylvania, and I think a lot of the common interest statutes that came from the uniform statutes, they provide that you can fine for violations after notice and a reasonable opportunity to be heard is provided to the unit owner. So you have to provide the due process because if you don't, people are going to wonder why they're just getting a fine, right? The pattern is violation occurs or proposed violation. Issue notice and say, looks like there's a violation. We want to meet with you to talk about it. You can meet with us and we could talk about it. And by the way, this is where I was going to go. That opportunity alone sometimes helps reduce the entire conflict or avoid it or tamp it down, get rid of the conflict because sometimes people just need to be heard. It's like that struggle. They need to be heard on the issue. And when you give them the opportunity to be heard, sometimes it goes away. You resolve it and you're done. No fine gets issued. You don't go to court on it. So follow the statutes if you have them and give due process. Jerry.
Do you not find that you give notice to an owner and they just ignore it?
Yeah, that happens all the time.
I mean,
Yeah.
90%, 95% of the time, just ignore it.
Yeah.
And then they get something.
Right. So the notice that I put together is very simple. It basically says we're going to give you an opportunity to be heard. Contact property manager or whoever within 10 days. We'll set it up. If we don't hear from you, then we're going to assume you don't want to meet, and they're going to issue disposition on their own, and it may include a fine, right? Or if they do respond and then they lose, same thing, but at least you gave them the opportunity to be heard on the issue. So, and by the way, of not doing this may lead to a successful lack of due process defense by an owner. 5, stopping unofficial enforcement. What does that mean? It means, I call it unofficial enforcement. It's not really a legal term of art, but it means when the board doesn't make a decision on something, the entirety of the board, whether it's one board member or it's someone walking the neighborhood, the sheriff, the architectural control sheriff, walking around with the badge and the cowboy hat and looking for violations, telling people they need to rip a deck out. I've had that happen. I had a situation where a member of a committee told a unit owner to rip their deck down, and instead of contacting the board or the property manager, they had a contractor come rip the deck down. It was like a $30,000 deck. And this was me. For the people listening, me is, oh my, what are you doing? But that committee member had no authority, arguably a parent or authority, but had no actual authority to do that. Similarly, a board member can't do that on his or her own. So if you tell someone to do something, you have to have authority to do it. And if you don't have authority to do it, it often leads to conflict. So we want to do it the right way. Number 7, communication between residents and associations. I touched on this earlier. Make people, give them a chance to be heard. Make them feel like, I mean, sometimes it's difficult when some unit owners are just constantly barking at a board president or a board member or a property manager, but give them an opportunity to be heard. Even if it's not the official, don't ignore them. If they're calling you and they're telling you there's a problem, look at it. I tell the boards, look at the problem and see what this really is. It might actually be a problem, and it might end up solving a lot of problems later on. For associations that don't require open meetings, make some of the meetings open. And I know people balk at that sometimes. 12 a year if you have, make 4 open. Be reasonable. If people want to be heard, and you'll know in those communities when the people want to be heard because the squeaky wheel gets the grease. 8, neighbor-to-neighbor disputes. Take them seriously. And 10 years ago, neighbor-to-neighbor disputes, a lot of association lawyers were like this. Well, that's between the people, right? That's between the neighbors. It has nothing to do with the association. Why are we going to get involved? Now, a little different, because the HUD final rule from 2016 came out, and is the hostile environment harassment is really the focus here. That can lead to third-party liability. So the association can face third-party liability for things that another unit owner does to a unit owner does to another unit owner, if it's qualified under the Fair Housing Act as a protected class, et cetera. But the association bears some responsibility to act. And the language in the rule basically prescribes that enforce the documents. Look at the documents and see what you can do. Is there a nuisance provision in there? Is there something in there that you would be able to point at? And don't ignore it. Don't sit on your hands. I tell boards this all the time. So that was a game changer. In the last 2 years, I think, I've had 6, 7, 8 mediations based just on that alone when neighbors are going at it. I mean, I've had really crazy disputes happen and had to try to facilitate it and offered to say, hey, I'll serve as the mediator. Have them come in. We'll do a Zoom, whatever it takes, but let's get talking here.
May I add to that?
What's that?
I was just going to add, so that's primarily my business. I represent individuals, and I can tell you that 9 times out of 10, I will name the association as breaching their duty of reasonable and ordinary care, which is our standard in Washington.
Right.
My opposing counsel over here on 2 to 4 at all times knows it can get crazy, like you said. We've introduced the mediation program in our CAI chapter as well, and we would love for people to take the little ones there first.
Yeah.
They don't trust that CAI has the individual's interest in mind, so.
Right. And even when I offer, people say, well, the association lawyer, I say, listen, I'm just here to help you both get this resolved. If we can't, we can't, but let's try to do it. And in case everyone didn't hear, the proposal from a homeowner plaintiff attorney is to try to use mediation more often than not. And I say regardless of the size of the dispute or monetary value, et cetera, I think it's a good idea. Even if you want to call it mediation, it means let's sit down and talk about it, right?
I,
What happens in a case where one party is not willing to have a discussion with the other?
You can't force people. If you have a voluntary, if you have a statutory mediation provision, some of them are mandatory before you can go to court. Others make it purely voluntary. You can only lead a horse to water, and I've had that happen where two competing Hatfields and McCoys. Hatfields say, you know what, okay, we'll go, and then the McCoys are like, we're not going to go anywhere where the Hatfields go. So you can lead a horse to water, but you can't make it drink. So you can't, I try and have that discussion.
Right.
I'm sorry, I can try to have that discussion with the McCoys and say, hey, you might want to really consider this. And I'm sorry, who did I interrupt here?
Thank you. On your previous slide, you first bullet point choose to act as intermediary. That would be counterproductive if the board member who chooses to do that has no training in dispute resolution.
No, I would recommend I do it with the board member on behalf of the association and have the unit owners sit across from each other with us there to be the actual facilitator of the proceeding or the mediation, even if very informal, I'm saying, aside from hiring a formal mediator and going through a formal mediation process. I'm just trying to nip things in the bud before they explode most of the time. So I would typically never send a board member alone or a property manager alone unless they felt comfortable. But I mean, I would offer as association counsel to facilitate that process, to be referee probably. Yes, Scott.
And my problem with that is my board member clients are always going to screw it up.
Yeah.
In person, sitting at that table, even with me there, they will say something stupid, and we always make it worse. Every single time.
Yeah. Well, it's the same comment over here. You can only lead a horse to water, Scott.
Every time.
Yeah. I know. I understand. All right, I'm going to hand this off to Emmy in a second.
And I have a,
All
oh,
right.
go ahead.
Not this time, though. All right, go for
I have a
it.
question. And anybody, I'm looking for some insight. The informal sit-downs, as you're discussing with,
Yeah.
you know, either association counsel or the community manager trying to bridge a gap or whatever, how successful are they in the absence of a hired third party coming in to kind of be a mediator?
It depends on, I
Because-
guess, the severity of the issue.
But you had it work. Like
Yeah,
I
oh,
clearly
definitely.
from the claims
Yeah.
perspective, when we get them, it's because it didn't work. You know,
Right.
so I've never seen it work.
No, it works. It
To
works,
Scott's
yeah.
point, it never works, right, Scott?
Well, there's also this, Scott, when they, you do the shush and the hand. So it's worked for me multiple times, and like I said, it's not real severe issues I'm talking about here.
Right.
Like people, it wasn't a drive-by or
It's a
something.
jurisdictional issue,
Yeah.
Pennsylvania versus Arizona.
Right. It's like Biggie and Tupac. So govern with empathy. What does that mean? Utilize emotional intelligence, exercise good faith, and employ due diligence. I tell the boards this all the time. I'm like, you're nice to your spouse. I hope you are, right? You're nice to your spouse. You're nice to your kids. You're nice to the people you work with. Can you be nice to the people that live there? I know sometimes it's difficult if the other people are rabble-rousers, but don't leave it at the door, Use some empathy in making your decision-making and also in dealing with the people. And a lot of times the conflict, will lessen or maybe not even occur. So I know. So we're going to let Emmy go now. So thank you for my 2 cents. Yes.
Yeah, so there's one question about you acting as the mediator.
Yeah.
So typically the mediator can't deal with anything that's told to them in mediation,
Right.
particularly when both parties are not together.
Yeah.
So if mediation doesn't work and then the association says you have to bring enforcement action, how would you navigate that?
Well, when I call it mediation, perhaps mediation is the wrong term of art. I'm really looking to sit down with the people and have a conversation. Not necessarily I'm not going to put them in separate rooms. I'm not going to go back and forth. I want everyone to sit at the same table and hear everyone say the same thing.
Do you make it clear to,
Correct.
you report to the board, you make it clear to the unit owner
Correct.
that whatever they say may be used in the
Yeah. Yeah. I mean, without trying to scare them. Right.
Do you
right.
record the proceedings?
I do not. Never record a proceeding. So, all right, Emmy, it's all yours. Thank you.
Thanks, guys.
Yeah.
So my part of the presentation is going to kind of talk about just different types of ADR and anchoring this in COVID. This could be particularly relevant. A lot of trial courts have huge backlogs right now because in some states they haven't been able to have jury trials. And so looking at these different types of alternative dispute resolution can be helpful. And we'll kind of go through the various types and then also the considerations that you might want to have as a property manager, a claims agent, or as an attorney, so that you can advise your board about which ones might be the most applicable or helpful if you have a choice. So the first one we'll talk about is just some general considerations that you want to have up front before you talk to your board members. And these are the kind of first considerations you'll have whether you're advising your carrier client or your board. And it'll help you, if you have a choice on which ADR strategy to choose in choosing that strategy. So costs is a huge one. Litigation can be extremely expensive, especially if attorney's fees are involved. And so the various ADR strategies have kind of their own inherent costs involved. And they sort of are on a spectrum, I'd say, from arbitration, which can be very costly because you have a panel of arbitrators in some instances who you're going to split the cost for their time. Those proceedings can last, on an expedited schedule, 6 months, but you could still have discovery and experts and all of the costs that would be generally associated with litigation. And then all the way down to, this should be judicial settlement is the last one. And that's available in some jurisdictions, usually after litigation has commenced, but it'll generally be referred to just a sitting judge or chancellor, and it's cost-free completely. And so thinking about these different strategies and the cost that might be involved will be pretty necessary when guiding your board or your carrier about which one to choose. Then, of course, you would want to think about the governing laws for different ADR strategies. If you're in arbitration, you're usually governed by one of the Uniform Arbitration Acts. Sometimes with arbitration in particular, the arbitrator will relax the rules of evidence or the rules of procedure. So in some cases, based on your facts, that could be super helpful. In other cases, that might not be so helpful because you might be kind of relying on evidentiary rules for exclusion. You might want to keep out hearsay, and in some arbitrations, you won't be able to do that. And so that would be something to keep in mind as you kind of navigate this with the board. And then some, state law is just super favorable depending on what your issue is. If you know that there are a lot of cases directly on point, you might want to recommend a strategy where you're going to have some kind of legal analysis involved so that you could mention, hey, we might be able to file a dispositive motion early and get this case dismissed, and that can really help you as far as negotiating those claims. You'd also want to talk to your board or your carrier about scheduling. If you're going to be scheduling with a panel of arbitrators, allowing time for discovery in an arbitration, that's obviously going to be a more protracted timeline than just getting together with a mediator or just negotiating something informally. If you are doing a judicial settlement conference, you have to kind of think about the docket of whichever judge or chancellor you might be trying to get on. And then finally, a lot of board members will want to know about what level of participation they might have to be expected to be involved in. And so some, obviously if you have arbitration, you're going to have board members that would likely need to testify. Some board members might, feel skittish about that. All the way down to mediation, where sometimes you don't have to have a board member present at all. If you've gotten settlement authority and you have spoken with your carrier, then you can go just meet with the mediator yourself, knowing that you have your client's interests, and the board members don't have to be involved at all.
That's for you, Scott. Thumbs up.
That will work.
Just a couple insurance insights with regards to ADR and the different strategies. Just to keep in mind, if it is pre-litigation and you decide you want to mediate a dispute that has been relatively informal at that point, I would make sure that you put your insurance carrier on notice of that before you engage in that proceeding so that they're aware. Obviously, if there's any costs associated with it that you may want to seek payment from the carrier, they're going to want to have notice of that before you do that. If there's any settlement monies that you're going to be looking to the carrier for, they're going to need to have notice of it for that purpose as well. And then also, if you have already put your carrier on notice and you are going to participate in mediation, and if there is a reservation of rights in place, especially if the carrier has denied coverage in that reservation of rights on any basis, you may want to discuss with them that you're going to a mediation if the carrier hasn't assigned counsel to ensure that if that carrier intends to assert any of those coverage defenses and take a position of no contribution with regards to any settlement discussions you plan to have, you want to know that and have that addressed before you go and sit down at a mediation table. So you just want to make sure those coverage issues have been addressed, and that if there's any contribution, the carrier is aware and involved and has thought about, what they're willing to do. I've seen a lot of mediations where the coverage doesn't come up till you're at the table, and that can derail your mediation, your effort to resolve the claim. Sorry.
No, not at all.
What's your general thought about pre-litigation mediation from an insurance perspective?
Right, so I've not seen it a lot in the community association space, other than in maybe like developer matters where you sit down on those more complicated matters where you know what the damages are, you have a good sense of what it is, and you sit down. With regards to unit owner disputes, which is kind of our focus here, the allegations can be so erratic that sometimes you need that litigation to kind of define the battlefield, as opposed to getting into a mediation before litigation, and they just start throwing the kitchen sink at you. Not that they won't do that anyway, but
Jerry, I think.
With all due respect.
Yeah, Jerry, I think that that determination is probably something that's made if you have a clear liability case and the association's a defendant, and you have a smoking hot clear liability case that's going to be filed against the association, and you already know. I've done pre-litigation mediations over the years in catastrophic cases where there was, the defense was going to be very difficult. So a couple of them actually settled for something much less than a jury award would have been in the Philadelphia area. So I think, that's an important factor.
Just from the adjuster standpoint, I think it is helpful when, if there is a pre-litigation mediation, we then know as the adjuster, are we gearing up for a major battle here?
Correct.
Or is this something that we can quickly resolve?
Correct.
From a reserve standpoint, what kind of counsel we need to get on it. So sometimes it's great, and then if it doesn't work, at least it lets us as the carrier know, oh, we got to get everything, all of our ducks in a row to defend
Right.
this better.
And a lot of times you get a kind of a sense of the valuation of the case on both sides. If there's a huge disparity, then, discovery might be warranted because you might need to figure out, what do they know? Are they completely off base here or not? And so kind of breaking down these strategies, starting with arbitration. Arbitration is usually available just through written contracts. So you have to have a contract that says that the parties will agree to arbitrate. And usually, depending on which state you're in, that has to be something that is either separately signed by the parties or that the parties specifically acknowledge, because it does take away the right to a jury trial. And so some governing documents will contain arbitration provisions. This is an excerpt from a declaration that I had in a case that basically says if the association or any unit owner asserts a cause of action against all of these various parties, the contractor, the developer, the association, any of their representatives, property manager, that the action would be decided by arbitration. It's set forth that the arbitration would be governed by the AAA, which kind of comes along with its own set of forms and fees and rules. And so this was an interesting case, actually. It was representing a unit owner against a contractor on a flooring issue, and we had to go to court and argue after the contractor had moved to stay the case and to compel arbitration based on this provision, whether this declaration, which is a contract between the association and the unit owners, could intend that this contractor was a third-party beneficiary that could benefit from this arbitration provision rather than going through the courts with litigation. So it can bring up these interesting issues, and a lot of times it'll depend on the facts. In our case, it was whether the unit owner had seen the declaration before purchasing the unit and had specifically agreed to this arbitration provision in the context of what he would say was a construction defect with his flooring. Now, sometimes if you have it in a written contract, it can be governed by the AAA like there is here, but you can also have just a general arbitration provision where the parties will just pick an arbitrator, and then the arbitrator can kind of more informally set rules. The AAA usually requires, like I said, certain forms that you have to use, certain fees at every stage of the litigation. And there's a little bit more kind of flexibility if you have your own independent arbitrator who can say, we're going to, kind of throw the rules of evidence out the door for this, or we're going to, stick with this certain procedure, we're going to do limited discovery. And some of those kind of procedures for arbitration, if you have the model rules, that's all set forth. You can look them up online, and you would want to familiarize yourself with those, before engaging in that or advising your board. But if you have kind of a private arbitrator, you can have evidentiary rules that are relaxed, for example. So in one of the arbitrations that I did, the arbitrator said, even if something is going to be hearsay or any other evidentiary objection that you would ordinarily lodge, you can note it, but I'm going to listen to all of the evidence, and I'm going to make a decision at the end regardless. And that can be valuable, consideration, like I touched on earlier. If you're relying on that evidence to be excluded, pursuant to some exclusionary rule, that would be something that you'd want to kind of consider as you go through this. And then the parties will usually engage in kind of a modified discovery period. It might not include interrogatories. Usually it's just kind of document production. You might take 2 or 3 depositions, usually like a 30.026 or 30B6 representative of a company, if a company or an association is involved, and then sometimes key witnesses who are limited. The arbitration is usually around a conference table. It can last a couple days. You present everything to the arbitrator, and at the end, the arbitrator will issue a decision which is final and binding. And there are very few instances in which these awards can be overturned or appealed to the trial court. Usually it's pretty severe corruption or fraud or a failure to postpone a hearing if there's been sufficient cause shown for a continuance. Another one would be refusal to hear material evidence, which is a lot of times why arbitrators will say, look, I'm just going to listen to everything. And that way their ruling isn't subject to being overturned because they might have left something out or excluded something that should not have been. Then we've got mediation, which I think this is probably the ADR strategy that most people are familiar with. It's pretty informal, used in a lot of cases. And I found this kind of continuum, which is pretty helpful, I think, if you're trying to advise your claims agent or your board, basically saying, if you have a choice of dispute resolution, your considerations are kind of at the bottom. Time and resources that increase as you go through the strategies towards the right, the party control that decreases as you go through the strategies towards the left. And so negotiation, obviously, is something completely informal, kind of like what Ed was talking about. You can sit down with the parties, negotiate between them. A lot of times if you have a pro se unit owner, there's no other attorney involved. As long as you've made it clear to that person that you represent the association, it can be helpful to just talk things through, see if they're reasonable, and try to get out ahead of a conflict if that's possible. And then, of course, mediation.
Can I ask a
Yeah,
question?
sure.
I want to ask a question to the I was going to say the members, the group here, the audience. The ADR provisions that Emmy was referring to, how many people have mandatory, arbitration provisions? How many people have mandatory arbitration provisions frequently in their declarations in their state? Okay, that's interesting. In Pennsylvania, we don't have them a lot, and I don't know about New Jersey. I don't think I've seen them too much in Jersey as well. So, but even my mindset on this is even if there is a mandatory arbitration provision, AAA arbitration is so expensive. If the association is paying out of pocket, or even if the carrier is paying out of pocket, it's typically so expensive. I think it's a $75,000 threshold. If then it becomes a major dispute, it's like then it enters a commercial track. That ADR process or that arbitration process works for like a commercial setting for disputes about damages, contracts, money. In our world, it doesn't. A lot of times, it just doesn't. It's so it's more expensive than going to court sometimes.
Yes.
So I ran into it years ago, and then this community revised its declaration, but I said, you don't need to go to it. It says it's mandatory before you go to court. You can't go to court unless you, but I said, do mediation. There's nothing, it's voluntary. If you both agree and you agree to what the mediator finds, great. you don't have to go through AAA and save, you know what I mean?
Yeah.
So anyway, I'm sorry to interrupt, but
I'm really, oh, go ahead, Michael.
I was going to speak to what Emmy said too, is and to what you just said, even if it says you have to, both sides can agree to waive and go to something different that will serve the same purpose. And it's gotten so expensive to the point that AAA is definitely the most expensive, but even WAMs and JMs and JDR, which I like a lot, but they all have a level of administrative fees that they're now individual former judges and
Correct.
individuals who have come out that are doing away with the administrative fees that really take it down a notch for a $30,000 dispute or a $20,000.
correct, right.
I think that the areas where it's probably the most effective is if you have like a large scale, like construction defect claim against a developer where you have like a very specialized set of law. And in some cases, then maybe it is more helpful to have an arbitrator who has a lot of experience in construction, who instantly can identify what the claims are. For typical homeowner disputes, I would agree. I think absolutely the party should not, try to get that resolved through AAA.
I don't think they get into it early enough to save much money.
Yeah.
Right.
Right.
Absolutely.
And I actually wanted to ask that question of the group as well. I had an interesting conversation with a community manager who is not a CAI person, who was emphatic about recommending arbitration to his clients. And I personally would never recommend a voluntary arbitration. I would always suggest mediation as the course because of the expense of arbitration. And
Right.
I've seen cases get caught up in the arbitration process without the framework of court deadlines. The things can drag on so you're not saving time, you're not saving money. But is there anywhere, any jurisdictions in this room where you would recommend a voluntary arbitration at any point?
Without mediation?
Yes, like if given the choice of voluntarily going down a course, you would suggest arbitration instead of a mediation.
When there's not enough buy-in on one side. I take the pulse of one side. If it's a waste of time, I've settled many things that I thought might be a waste of time. So
Right.
if there's an inkling, I'd go. If they're so far apart that it's never going to settle, then yes.
So you would go to arbitration instead, voluntarily, as opposed to going to court. Like if you could just go to court.
If we get to choose the arbitrator, I'd much rather have my hand
Okay.
in choosing who's
Good
going to
point.
decide this thing.
Yeah. Good.
Well, the other problem is, for instance, 20 minutes after that, and Andrew might make it worthwhile, there's generally no appeal.
Right.
Arbitration. So if you get a bad decision,
You're stuck.
You're stuck with it.
Yeah.
I've done hybrids. Usually retired judges who would be willing, a lot of professional mediators just won't do it. But you start as a mediation, where parties agree, we'll resolve what we can, and what we can't. We agree that at this hour, the mediator becomes an arbitrator and makes a decision what we do down by.
Interesting.
Yeah.
That works really well.
Yeah, I've never.
But that opens up I'm going to hold my cards too close to my vest because that same person is going to make the decision without the protections of some evidence.
We got 20 minutes left, guys.
Yeah.
Yes. Yes.
The way you're talking is it's an alternative. It's not an alternative. Mediation can take place before.
Oh, absolutely.
Anytime.
By choosing mediation, you're not foregoing anything.
Right.
Choosing arbitration, you're not foregoing mediation. In fact, I do a lot. I listen to mediation while the arbitration is going on.
Absolutely.
While the lawsuit is going on.
Sure.
Right. I think mediation, partly because it is, so easy and it's something that parties can engage in pre-litigation or throughout the litigation, and it really acts as a way that you can, either apply pressure to a party or at least get a sense of the valuation of the case and how far apart you might be. It's certainly beneficial to engage in throughout as often as you think that it would actually be beneficial or effective.
We use it as a defense, a good amount, like if the documents they have to go to an alternative dispute before you can file the suit. And we have some with you guys.
Yeah,
where we've used that, and sometimes they don't, we've had them thrown out by the judge, case dismissed, moved for a motion to dismiss the case because they failed to comply with arbitration. Or any type of alternative dispute resolution, whether it was a mediation, a meeting, a hearing, anything.
Right.
And then sometimes they don't refile, and then we just, we've won the case.
Right.
And other times, we've got one of you right now where they did refile. It's the point I'm making is use that as a defense.
If you have it, yeah, if you're required to do it and they don't submit to it or don't cooperate in the process.
Or, it can also be used as kind of like a negotiating tool. If you know that there's an arbitration provision, you can use that to say, look, do you really want to put up the money to go to arbitration, or do you want to just get out ahead of this and try to mediate it or negotiate it up front before having to incur that cost? The next strategy is judicial reference. This is something that I was not familiar with coming from Tennessee, but in California, these judicial reference proceedings are kind of overseen by a special master or retired judge who's been appointed to hear a dispute. And the parties can either agree to do this at any point in the litigation, or sometimes there will be a contract that requires it. I'm going to just kind of quickly go through this. The proceedings are usually governed by the same kind of rules as you would have in trial court, so evidence, procedure, discovery. But unlike arbitration, the award that's issued at the end of the judicial reference is subject to appeal. It's usually got the same standard of review that applies to the appellate court review of like a trial court decision. And I kind of wanted to talk about this case, but for time, basically this was a case out of California that essentially said that if you have a judicial reference provision or requirement in your governing documents, it might not always be enforceable because you are giving up that right to a jury trial. And so for time, well, if you guys would like to look this case up yourselves, it is a great case. Then there's also judicial settlement conference. This is also available in some jurisdictions, I think not others. It's pretty similar to mediation. Usually the difference is that the judge or chancellor might require certain topics that they want you to outline in advance of going to the judicial settlement conference. Kind of what Ed was talking about earlier, this sort of opportunity to be heard, especially if you're dealing with a homeowner or unit owner dispute. A lot of times judicial settlement conference can be super beneficial for that purpose because you have a judge, they're usually in their robes and you're in chambers, and so the party, this unit owner who's engaging in this mediation process, has the chance to be heard by a judge, and they can kind of air all their grievances. And a lot of times that goes a long way in allowing that person to kind of come to a more reasonable position and accept some sort of settlement. And so this is usually the most cost-effective because the judge obviously doesn't charge anything, and that can be helpful if that's something that your jurisdiction provides for. We also are going to kind of touch on attorney's fees awards. Obviously, some enforcement provisions in governing documents will allow you to collect attorney's fees. Sometimes the language is a little bit squirrely. It might be if you're the prevailing party or the substantially prevailing party, and sometimes you have to litigate what that means exactly to figure out what that award might entail. Sometimes attorney's fees are only allowed in certain types of claims. So if you have like a collection action for unpaid assessments, you might be able to collect attorney's fees. Whereas if you have like a different type of dispute involving maintenance or some, restrictive covenant that's been violated, you might not be able to collect them in those instances. And some governing documents will limit the recovery of attorney's fees to actions. And so there's a consideration as to whether you can get your attorney's fees taken care of for any kind of pre-litigation ADR. California, again, has a really interesting statute, the California Davis-Sterling Common Interest Development Act, which requires parties to engage in ADR before filing enforcement actions in circuit court. And they have a case that essentially extended that attorney's fees award even to pre-litigation ADR mediation that the parties had engaged in.
We're talking about circuit court there, that's going to be federal court situation, isn't it? There's no circuit courts in state court in California.
That's a Tennessee term. In Tennessee, our circuit court is just like our civil court. Yes, yeah. So sorry about that.
I thought it was a state act, but circuit courts aren't state courts.
Right. That will depend on your state.
Well, you do things differently.
That's right. We do a lot of things differently in Tennessee. Lastly, I just want to touch quickly on some advantages and disadvantages of virtual ADR. Obviously, it's efficient. You don't necessarily, if you're in an ADR setting where you don't have to present evidence or testimony, it can be very efficient. It can be easy to get those scheduled. You just appear on Zoom from the comfort of your home. You're not worrying about transportation. And then, a lot of times, especially in this kind of environment we're in, if you've had a party or the mediator or one of the attorneys or anyone involved in this process who's had a COVID exposure, who's been actually has COVID, you can still allow that to move forward as long as they're on Zoom. They can still be quarantined. And then there's also some disadvantages. I'm sure everyone remembers the cat, which was super cute. So obviously tech difficulties are, something that everyone experiences. Now, if you're in a court setting, a lot of times they'll have dedicated IT, but if you have an ADR procedure like an arbitration or something that's a little bit more complex and you don't have dedicated IT, that can cause a lot of stress. Presenting evidence and testimony can be more difficult if you have exhibits that aren't something that you can, put into an electronic form. That can be harder to present to your witness. And then obviously just even connecting to witnesses, connecting to the decision maker is a lot more difficult over Zoom because there's sort of that virtual wall there. It can be more difficult to assess credibility. And then, for some disputes that you might have just with a unit owner, they might not have access to Zoom, they might not have internet, they might, have the Zoom on their phone and you can only see their chin the whole time. So, there's certainly disadvantages there as well. And I'm so sorry about the time, but
That's okay.
pass this off.
All right, very
Yes.
good. So I have 9 minutes, and it's not nearly enough. Well, that's why I did that. All right, so talking about insurance considerations that persist in ADR and litigation. So I wanted to talk about a few things. I want to keep it high level so we can keep moving on it, that can frustrate community relations, the relationships in your community, either by voiding or losing your insurance coverage and not having a carrier able to come in, and or issues that come up with regards to insurance that can spur infighting among board members, between the association and committee members and those sorts of things. We see on the D&O side of claims a lot of times where it is something maybe in the insurance process where they start pointing fingers at each other and who didn't do what right. So the first one is with regards to the application. Let's just start at the beginning. With regards to misrepresentations in the application, I'm seeing an uptick in attempts by carriers to rescind insurance policies based on misrepresentations in the application. And the courts are taking deep dives, to determine who actually knew what when that application was completed. And, as the board member who's completing it, who's completing that application, is the board member's knowledge or lack of knowledge imputed to the association generally? If the board member filling out the application did not know that board member B actually did receive a complaint, and they didn't disclose it on the application, is that determined to be a misrepresentation because they're all representatives of the association and this board member didn't disclose it because he didn't know it? Those sorts of things are coming up. What if the application is unsigned? I'm running from here to do the SERMS case law update. And one of the cases that we're discussing there is a motion for summary judgment that had been filed by our carrier saying you didn't disclose you knew about this threat of litigation, you didn't disclose it on the application. You knew about this damage to your roofs, you didn't disclose it on the application. All this information that had been going on for 10 years, you didn't disclose it. So that's a misrepresentation. We're going to move to rescind the policy. Court denied that motion for summary judgment. It's the association's argument. We never reviewed, completed, or signed that application. Our agent did it. So we didn't misrepresent a thing. He said no, but we didn't see it. So, that's an extreme case because I'm pretty sure none of the agents that I do work with would ever complete it and not have the association sign it, review it.
So is that agent contacting his E&O carrier?
That's actually a comment I'm going to make.
As we speak?
Exactly.
Right.
So those sorts of things, it's something that the association needs to keep in mind when they're completing the application because you don't want to be in a position where the carrier is able to argue that that policy is void and because you didn't disclose things you should have disclosed. We talked about notice a little bit with regards to pre-mediation. But it's important to make sure you have the ability to call upon your insurance carrier, and the only way to do that is if you provide them with notice of things that policy requires notice of. So you need to go to your language of your policy and find out what do we need to report and how do we need to report it. There's case law regarding, if a claim hits the news and you presume your carrier knows about it, because Champlain Towers, let's talk about that, right? Everybody knew that happened. I'm sure the carrier knew that they had that claim, they would have had that claim before they ever got reported to them. But is that sufficient if it wasn't actually reported? Generally, no. If I'm aware of a claim and I don't submit it to the claims department, but I put it on my renewal application, is that sufficient? Courts have held no. So you have to be very aware of how you have to report it. Internal discord on whether to involve insurance. How often we get late notice because everybody's fighting about whether to report it or not. They don't want to risk the increased premium. They don't want it on their loss run. Claimants, crazy, and they do this all the time, and we can't get insurance involved every time. So that causes infighting in the community as well, whether or not to even just report it.
So how many association general counsel here have told their clients, report it, report it, report it? And how many times have they said, do we really have to report it? Or we don't want to report it?
Right.
Is it necessary? Are our rates going to go up? That's usually what I get.
Yeah.
I'm like, I don't know. I'm not Kreskin here.
Like,
The concern I've had for some of my association clients is being dropped if too many claims.
right.
How do you overcome that?
Right.
Way of
It happens.
the reporting requirement?
Yeah, exactly. So there's a balance that has to be found there, and it's going to depend very much on the individual association. Most of the carriers that I have worked with or have spoken to their underwriting people, the rules are basically, you report it, and you don't get dinged for it unless there's cost incurred on the file, right? Because you have to provide notice on the policy. So as long as there's no cost incurred, notice of a potential D&O claim. That's the big one that comes up, right? Because you don't want to over-report that stuff. And when there is a frequency of claim reporting with those zero incurreds, most of the time, from an underwriting perspective, we're looking at what's happening in that community that's causing all of this stuff. If it's just random, you've insured that association for a decade, and this is just this strange occurrence over the last, maybe a board wants to report more than in the past and whatnot. So
Imagine payment of claims is more important.
payment of claims is much more important than yes. Yeah, and I always say you don't know which one's going to be the $1 million claim. Who is seeking the coverage? Lots of infighting when you have claims and cross claims and counterclaims, buy-in among association board members, prior board members, property manager, former property manager, all of which have defense that we have an obligation to defend depending on the allegations of the complaint. The associations lose their mind when they hear that we're paying for 4 defense attorneys because we have, 2 or 3 on the defense side, and then you filed a counterclaim against the plaintiff, and now we have to hire counsel to defend them on the counterclaim. So this is the sort of thing, and as the carrier, we need to look at that. When we get a complaint, and when it's tendered to us, we have to say, who is tendering it to us, first of all? Is it the association? Is it the property manager? Is it a board member? Is it the plaintiff, unit owner? Because unit owners sometimes have rights under the liability policies, depending on the allegations. And we have to, parse out who's getting what coverage there. It can make the litigation very expensive, and it can cause a lot of consternation for your boards. Other issues, some exclusions, breach of contract, can cause some infighting amongst board members. Deductibles, when there's a deductible owed, how you can collect it, who can you collect it from. Voluntary payments, again, with regards to the notice, if you have these informal sit-downs, you have mediation, the board, the association agrees to pay something, and then they come back to the carrier and say, oh, by the way, we did this. Can we have some money, please? No, you cannot. Evidentiary issues. This I wanted to raise with regards, I'm talking really fast. Is it too fast? With regards to the board training that we mentioned earlier, super important to talk to your boards about the maintenance and production of the documents that are going to be necessary in litigation. Many states have rules and statutes regarding, what documents need to be maintained and what documents need to be produced on demand. I mean, even in the absence of litigation. Who's maintaining those documents? You know, and with regards to email, as your board is turning over and you have new members coming on, what is happening to all that old email that's sitting in past president's email box that he's going to delete or get rid of or whatnot that may be relevant to litigation that you may need to produce? You don't want to be accused of spoliating evidence because your prior board president deleted his Gmail account.
Right. I see people, you know, have like their work email from Merck as they use for the board. And I'm like, no. Like create president at whatever HOA at
Yes.
gmail.com email and use that. Don't use your work email.
Right.
And I also tell them this is something that you'll enjoy from the carrier perspective. You touched on it. Everything's admissible, meaning board emails to and between and from each other. I've had, unfortunately, in court, their Exhibit A is calling the plaintiff a XYZ, and then Exhibit B is calling him an ABC, and you know, they're 4-letter words, even though I'm using 3. But they say, well, that's all privileged. I'm like, how is that privileged? It's board communication. I'm like, no, it's not privileged. You guys are emailing each other, talking about things in email. So anyway, I'm sorry to interrupt, Jen.
Yeah, no, and I just fast forwarded ahead. This was kind of like the summing up slide. So, you know, what are the consequences of these, you know, complications from an insurance perspective? Significantly higher indemnity and defense costs if there's a lot of infighting. The impact on the community association, loss history, loss run, the inability to get insurance can be an issue. And additional litigation because of poor community morale. People just, once they're fighting, they love to keep fighting. So, all right,
Well,
that's all, folks.
Well, thank you.
Thank you.
I think we had, you got to run, right?
I got to run.